Hey everybody! Today's video lecture is going to be looking at the structure of the federal judiciary. Here we have a diagram of the federal structure. I want you to notice that it's three distinct levels: the Supreme Court at the top, the courts of appeals, and then at the bottom, district courts. Specifically, the courts created by the Constitution are the ones outlined in this dark black box. Notice at the top sits the Supreme Court, and underneath it the courts of appeals and then district courts. The Constitution was actually vague about the structure of the federal judiciary, mandating only a Supreme Court. The courts that you see below it, any of those courts below the Supreme Court, were created by the Federal Judiciary Act of 1789. The only court that cannot be removed is the Supreme Court. Congress could, however, if they want, remove or add any court below it. Looking at this diagram, we can see that the court system has a hierarchical structure, meaning the greatest power is at the top. And again, Congress is able to establish or dismantle any inferior courts. Now, in the federal judiciary, if we look at that diagram, the courts of the federal judiciary are the U.S. district courts. District courts were created by Congress in the Federal Judiciary Act of 1789. U.S. district courts are considered trial courts in the federal judiciary, and they have what we call original jurisdiction. This means they get to hear a case first. It is in these district courts that trials are held. There are juries. Juries are meant to hear testimony, look at evidence, and decide the facts of a case. Many cases that are decided in U.S. district courts will ultimately move forward and up that hierarchy through a process known as appeals. We have 94 district courts in the United States and 663 judges. All judges at the U.S. district court level have been appointed by the president and confirmed by the Senate. In this map here, you can see the jurisdiction of district courts and also courts of appeals. District court boundaries do not cross state lines. Moving up, we have 12 judicial circuits in the courts of appeals, that middle level. Each judicial circuit in the Court of Appeals serves at least 2 states. You can see, for instance, the 7th Courts of Appeals in the federal level serves Illinois, Wisconsin, and Indiana. These 12 circuit courts are known as appeals courts, and they have what is known as appellate jurisdiction, meaning the cases that they hear have to be brought to them based on appeal. They don't get to hear a case first. So a case has to have been heard in a lower court, a decision made in that lower court, and then appealed to that next level. There is no trial, there is no jury, there is no testimony given in the circuit court, just a strict review of the facts of a case and the decision of the lower court to see if it was correct. Decisions at this level are heard by a panel of 3 judges who review and hear the facts of a case and then only decide if the lower court's decision were correct or if they are going to overturn it. Decisions by U.S. circuit courts set precedent for the courts below them, meaning that whatever decision they make, if a lower court hears a similar case, they have to abide by the decision made by the court above them. Now, while circuit courts and also the Supreme Court are appeals courts, there are going to be a few instances in which a federal court might have original jurisdiction, not heard at the states first. One of those would be if the law that's an issue is a federal law, if a case is involving a treaty negotiated by the president and ratified by Congress, if the case involves an issue involving the U.S. Constitution, or a case where the U.S. government is party to the litigation. So for instance, the case of U.S. v. Lopez, right, where the U.S. government was a party to that case. They were either bringing the case to the court or the defendant in that case. It could also be that the federal government might play referee in a case that involves two states. Here, you can see how a court might move through the federal judiciary. Sometimes they are starting in those district courts, moving through the courts of appeals and up to the Supreme Court. Sometimes a case that has moved its way through a state's judiciary, all the way, for instance, up to the Wisconsin Supreme Court, can be appealed from the Wisconsin Supreme Court to the Supreme Court. But there's other courts here too. We see military courts that might be added and appealed up to the Supreme Court. We might also have courts of international trade and courts cases then that work their way through appeals for specific issues that Congress has said we want these courts to be able to deal with. I do want to reiterate here that the structure at the top of the Supreme Court is the only constitutionally required court that is established through Article 3. Talking a little bit about the Supreme Court now. Cases, again, are going to reach the Supreme Court through appeals in most cases. So again here, like the courts below it, right, this is an appellate court. The SCOTUS, Supreme Court of the United States, has appellate jurisdiction, meaning cases have to be appealed to it. There are some instances where it has original jurisdiction, and I'll show you those in just a second. But for the most part, the way that those cases are going to move through from the district courts to the courts of appeals to the Supreme Court will be through the appeals process, which means not every case that is appealed is going to make it. And we'll talk about that because the Supreme Court has a very limited docket, slate of cases that it can hear. So here would be how cases would reach the Supreme Court through appellate jurisdiction. So through that process of appeals, we have the state route where it's reached a state Supreme Court and it's appealed here. It might come from those legislative courts or those federal courts of appeals, or most likely the U.S. courts of appeals going through that federal route. But there are some instances where it may act as a trial court, where it has original jurisdiction. Instances here would be a case involving, for instance, the United States and a state, a case between two or more states, a case between a citizen of a state and a state itself, or perhaps between a state and a foreign country, or any cases that might deal with foreign ambassadors. So these would be the limited instances in which the Supreme Court acts as a trial court. Here is a picture of our current Supreme Court of the United States. Right now, we have 6 more conservative justices and then 3 more liberal justices. I think it's important to reiterate that at the SCOTUS level, again, SCOTUS standing for Supreme Court of the United States, we call them justices, not judges. This is the only place where we use the term justice rather than judge. Right now, there are 9 people sitting on the Supreme Court. This number is not constitutionally mandated, and it has changed over time. Congress, again, gets to set the number. So you can see when the Judiciary Act of 1789 was first passed, that's the same act that created the lower courts in the federal judiciary. It set it at 6 Supreme Court justices. It's been reduced, it's been increased. At its height in 1863, you notice that there were 10 justices, then it was reduced. But ever since 1869, the number of Supreme Court justices has been set at 9. Now, in general, the Supreme Court will hear roughly 80 cases a year. And the Supreme Court gets to pick and choose. Thousands of cases are appealed to the Supreme Court every year, and they hear, again, only about 80 of them, so a limited docket. What influences the Supreme Court in terms of the cases it will take, a lot of times they're going to pick things that interest them, that are of controversy or a topic of interest to the Supreme Court. And they're going to get to have a lot of discretion, meaning choice, over the cases that they hear. Now, this is just a snapshot from a docket of cases back in 2012, 2013. And looking at where these cases are come from. So most cases that reach the Supreme Court are on appeal from those lower federal courts. Again, that's the most common route, but there are instances when the Supreme Court might pick and choose to hear cases from state courts as well. All decisions that the Supreme Court makes set precedent for all other courts in the country. And the Supreme Court is meant to ensure a uniformity in interpretation of national laws. So it's setting the standard for the nation at large. That is the end of our video lecture. So if you have any questions, please come with them and we'll address them in class tomorrow.